playing off your brand or making a false association between their entertainment channel and your shoe company, then there could be, questions about whether or not the channel's sponsored by the shoe company, in which case you might have some issues with that third party. Also can't likely register it depending on how well known the company is. So like I'm thinking if it's Nike, for example, and we tried to go register something kind of related to Nike at the USPTO for like travel entertainment, they're just going to say no. I'm going to be like, no, that's a famous brand, right? You can't do that.
Because I'm putting together a band and I want to name it Ladyland. Now, the problem is there's a Jimmy Hendrix album with the name Electric Ladyland. I checked the trademark sites and found that basically that in our music, could there be a problem with the name on its own? Oh, and our music doesn't imitate Hendrix in any way or is any similar. So
yeah, that's fine.
What do you think?
Yeah, fine.
Okay. Hey, all right.
I mean, so I haven't searched the USPTO. I haven't looked to see if anything's registered that would be a likelihood of confusion. But if that's your largest concern, is that there's a Hendrix album from 40, 50, 60 years ago, 60 years ago, basically, that is titled Electric Ladyland. And you want to name your band Ladyland. I don't have a concern with that at all. The Electric Ladyland album is not really functioning as a trademark. I mean, I guess it's a trademark for the collection of those songs, but I doubt it's registered as a federal trademark. So I don't have any concerns with that whatsoever. Ladyland should be good to go. Just have your attorney do a quick search at the USPTO to verify there's no other bands or, music producers out there using that name. A couple things about the music industry and like our clients in it. Typically, you're going to want to look at like two different classes of services or products when you're filing the trademarks. One's going to be like that live entertainment class. So class 41 application at the USPTO, music performances, all that kind of stuff is covered in there. And then you'll also want to look at the sound recordings themselves. So generally speaking, you want to register the sound recordings as a federal trademark as well under your brand.
That's awesome. Thank you, Matt. If I turn that question up a little bit, let's say that album just released last year by a different famous artist, would that change your answer?
Probably not.
Okay.
Probably not.
The fact that it was a long time ago isn't necessarily germane.
I don't think so. I mean, because, the album could be registered as a federal trademark, but then it's providing like the music recordings of the album, but that's different than like a live or a musician who has a band name, right? That's over here doing live music performances. I'd want to see like a more like, I guess, compelling fact pattern before I made a decision that was verboten or out of bounds.
Yeah, that's great. What's the average time it takes to obtain an international design patent? It's a very specific question. I will say there is no such thing as a single international design patent. You do have to register them in each country, just like you do on the trademark side, right? But what's cool is there are treaties set up on the utility patent side. It's called the Patent Cooperation Treaty. On the design side, it's the Hague Agreement, HAGUE, for industrial designs. And it's the way it works is you submit an application naming your home country, and then one examiner will represent the whole world or those that have signed on to the treaty, and that saves you time and money, not having to do the search costs at each country. Assuming it's novel, then you can proceed to file. Maybe you need to convert the application, follow the specific rules of the country, maybe get a hold of a local attorney in that country to file it and follow their specific rules. But yeah, that's the path. In terms of timeline, design patents are a whole lot faster than utility because design patents are really, for the most part, about the drawings. Yeah. And there's a lot less to fuss about. Don't get me wrong, some of them are, quite particular and can take a while, but I would say a year to 2 years, to get some rights within, internationally. Depends on how many countries, of course, but I hope that helps answer that. Trademark-wise, international, are some other countries faster now than the U.S.? I mean, what are some issues there?
All of them. This is not great. I was just looking at it. I had to email a client today some bad news about we had to refile for a trademark application for a variety of reasons. But yeah, it's frustrating. There's a lot of young examiners out there at the USPTO right now, which is great. It's just maybe a little bit more mentorship. Maybe someone should be looking over their shoulder before they issue all these crazy office actions. So
yeah, and they're supposed to be attorneys. In fact, they are.
Yeah,
they passed a bar exam. I'm sure.
They're all very smart people, but for whatever reason, like a lot of times, logic doesn't seem to make a lot of the logic doesn't apply at the USPTO sometimes. So like I'll just give you a quick example. I mean, I'm trying to make it as quick as possible. We had a client, not a bold, but we had a client basically that had to refile the trademark application. We took over the trademark registration. It's time to renew the trademark. The application was filed too broadly. So we got dinged basically for having to bring the application back in smaller. They had a lot of products that they weren't actually selling. Eventually, the USPTO said this trademark is basically dead. We don't think that you actually went to market with any of these products. So we had to refile the trademark application. But the client's been around for the last 15 years.
Crazy.
Well, while our trademark was registered, another trademark under a similar name was registered as well. USPTO didn't catch it. So that trademark registers. We file a new trademark application. But before we file our trademark application, another trademark application is filed for a similar name.
Oh, no.
That application is allowed to register. The third-party trademark that was filed during our old trademarks time period was not cited against it. Our client comes along, we refile the application, and now both applications, one registration, one application, are cited against our client. It's like, no, that makes no sense, right? So anyways, that's the logic you get at the USPTO, but they don't care. They don't want to hear it.
That's a mess.
That's the problem. It's just not fair, right?
And the business owners pay. They have to hire you to build.
Because I'm going to have to cancel the one registration now because they won't talk to me. The third party won't respond.
Yep.
And we're going to have to oppose this other application now too. And neither of these third parties are from the United States. So it makes dealing with them a lot harder.
My partner and I are currently traveling. I've been making social media channels to document our travels for family and friends. I highly doubt any of our channels will gain traction, but can there be any legal repercussions for using a brand name in our handles? In the event that we somehow gain visibility, it goes viral, right? Our channel name is popular outdoor shoe brand and a word that rhymes with it. But I don't know, someone may be thinking they're going to go viral with their travel, right? Yeah, they're dropping brand names. Repercussions, Matt?
Yeah, potentially. Like as a trademark owner, you have like the right to publicity of your own brand, right? And so if someone's playing off your brand or making a false association between their entertainment channel and your shoe company, then there could be, questions about whether or not the channel's sponsored by the shoe company, in which case you might have some issues with that third party. Also can't likely register it depending on how well known the company is. So like I'm thinking if it's Nike, for example, and we tried to go register something kind of related to Nike at the USPTO for like travel entertainment, they're just going to say no. I'm going to be like, no, that's a famous brand, right? You can't do that. So
okay, but I think they're asking, they're doing, they're talking about some awesome hike they just did, and I don't know, for whatever reason, whatever their commentary is so cool and fascinating, they get, 1 billion downloads, and happen to have a very visible shoe with a logo on it in the video clip.
Oh, that's fine.
All good. So Nike, even though it's very visible on that clip, it gets 1 billion downloads, whatever views and lots of attention, and they could get, affiliate marketing deals and monetize that viewership somehow. Is Nike going to be able to come back and say, actually, you probably got some of those views because of the recognition of our trademark? I mean,
you have to really look at that back pattern, right? Figure out what's fair use of the brand, what's promoting the brand, if there's a financial play there between like the sales of the company and their revenue. That'd be tricky. But if you're just, if you're reviewing a shoe, discussing a shoe, it's part of the video, that's fine. If it's in the title of the video, maybe not. If it's in the title of your brand, your travel brand, if you're like Nike Adventures, right? Can't do that.
Timberland in the hinterland.
Yeah, like really cute, really catchy. Timberland might be on board with that. They might be like, yeah, go for it. But until you get their permission to use their brand in your videos.
Very cool. All right, what is patent litigation? Patent litigation is when one individual, an owner of a patent, has a right, has been granted the rights from the USPTO, the exclusivity, being the only one to make, use, sell, or import that product into a U.S. or a country. When that individual, that owner, decides to enforce against a third party, they believe to be infringing the rights. And so 2 major types of patents. There's utility, which is the written words. You have to go see, is that infringer actually infringing each element, each word on that claim? Or if it's a design patent, does that 3-dimensional shape look close enough? Is it similar enough so that an ordinary observer would say, yeah, that is the same as what was on the shape of this design patent? That's what starts litigation. You can threaten litigation. Most cases settle well before they go to trial, but that's what it is. That's litigation. And you can hire private attorneys, individual attorneys to do that. No, there is no USPTO, enforcement. There's no police, right? So whether you have a patent, doesn't matter. You're not going to have a judgment or any type of a enforcement body act on your behalf. You've got to go out there and do that work on your own.